So we start with the lecture on contracts. I'm sure you are already familiar with the topic, particularly on the general provisions and also on discussion on consent. But because you already have studied it for the midterms, so we start. Uh, Article 1305 provides for the definition of a contract. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. You take note of the keywords here. When there is a contract, there is a meeting of the minds. It presupposes that there is a mutual assent or mutual agreement of the parties. In a contract, there is at least two persons, no, to a contract, and whereby one would undertake it. It it provides for the creation of an obligation, whereby one binds himself, with respect to the other to give something or to render some service. This has something to do with your obligation. Remember again the definition of your obligation. An obligation is a juridical necessity to give, to do, or not to do. So we all know that contract is one of the sources of obligation. And so when there is a contract, upon the meeting of the mind, it creates an obligation by one party with respect to another to render some prestation, or that is to give something or to render some service. Once, as a general rule, contracts are perfected by mere consents, mere consent, no? And it does not necessarily require that a contract must be in writing, but of course, there are different kinds of contract that they have to be in writing to be valid, or they have to be in writing for purposes of enforceability or for purposes of convenience of the parties. We will discuss these things later on. But as a general rule, there is a meeting of the mind when the parties agree or assent with respect to the object, and as well as the cost or consideration, and it takes place when there is an acceptance, of an offer by one party with respect to the other. You take note of the essential requisites of a contract. Your keywords would be consent, object, and cost or consideration. Consent of the contracting parties, object, which is the subject matter of the contract, and the cost or consideration of the obligation, which must be established. You take note of the difference between a contract and obligation. We learned from Article 1157 that a contract is a source of obligation, and an obligation is the legal tie or relation itself that exists after contract has been entered into. Hence, there can be no contract if there is no obligation, but an obligation may exist without a contract because there are other sources of contract. There are other sources of obligation other than contract. Contract is just one of the sources of obligation. Classification of contracts, you take note of these things. You take note of the definition, preparatory. Object is the establishment towards another subsequent contract. We have the principal contract. It subsists independently from the other contract. And then you have yung accessory contract. which exists as a consequence. Yung preparatory contract, it could be like, for example, you have an option contract. An option contract is in preparatory for the execution of an absolute contract or contract of sale. Or for example, it is a conditional deed of sale or a conditional contract of sale, or it's a contract to sell. These are preparatory contracts, which would lead to an absolute contract of sale. No, pag principal contract, they stand alone. Like if you have uh, a contract of sale, for example, or uh, a contract for deposit, or it's a loan contract, no. But for accessory contract, it could be a contract that is in relation or as a consequence of another. Like for example, the principal contract is a contract of loan with a subsidiary or accessory contract of a mortgage contract, no, which would secure a principal obligation. Or for example, it is a pledge. You have a loan, but it is secured by a contract of pledge with the delivery of a thing as a security for the loan, which is the principal contract. Then you have consensual and real contract. Consensual, these are contracts that are perfected by mere agreement of the parties. And then you have real contracts. So it requires the delivery of the object of the contract, which is required for the perfection of the contract. Then you have the common or informal, special or formal, according to form, either in writing or not in writing. No. And according to purpose, it could be transfer of ownership, like contract of sale, or conveyance of use. It means the delivery of a thing for the enjoyment of the other party, for their possession and enjoyment, with the object of returning the same thing. No, you would learn more of this when we come to sales and credit transactions, which is under regulatory framework and other issues in business, legal issues in business, or the rendition of services, like a contract of agency, whereby one would bind himself with respect to another to represent a principal. And according to subject matter, they could be things or services. So pag contract ay hindi lang yung sa bentahan ng lupa, hindi lang yung bentahan ng mga bagay-bagay. It could also be for the performance of certain service or certain services. And then you have, according to their vinculum, it could be unilateral, no? It gives rise and obligation only of one party, or it could be bilateral, yung reciprocal obligation for both parties. And then you have onerous or gratuitous. Pag onerous, it is consideration, merong bayad. Pag gratuitous, it is based by mere liberality of the party, katulad ng donation. Then you have nominate and nominate. Pag nominate, meron siyang sariling pangalan. Pag inominate ay wala siyang particular designation, like duotes, yung mga ganon. And then you take note of the characteristics of contracts. First would be the freedom or autonomy of contracts, no? It is in accordance with Article 1306, where it provides that parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, and public policy. Ibig sabihin nito ay in a contract, no, the parties are free to enter into any kind of stipulation, any kind of agreement that they want to. Hindi sila papakialaman, no? They are free to do that. They want to agree on the sale of a particular item, or they want to agree on the performance, for example, for A to sing or B to dance, subject to certain restriction, no? Because this freedom of contract is not absolute. Any stipulation in a contract must not be contrary to law, morals, good customs, public order, and public policy. Ibig sabihin ay hindi siya, walang dapat nilalabag na batas, and they are not also contrary to morals that are acceptable in a society. Like, di ba, we have discussed like yung for example, a woman would agree na maging common law wife, or maging yung term natin doon is kabit, no, in exchange, for example, 100,000 pesos, or in exchange na mabigyan siya ng bahay at tupa, yung mga ganon. Yung good customs naman, like, di ba, yung sa public policy natin under the law ay pag naghiwalay yung mag-asawa, there is a proper procedure, no? Nung paghihiwalay nila in accordance with the family code, they could either they go through yung legal separation procedure, or they could go through yung annulment or nullity of marriage. Pero if they just agree na magkahiwalay na lang at mag-asawa na lang ng bawat isa ng kanya-kanyang buhay, no? That would be contrary to good customs, no? Kahit they put their agreement in writing, nagkasundo sila sa barangay na maghiwalay na lang sila at bahala na lang sila sa bawat isa, that would not be in accordance with good customs. Then, of course, public order and public policy. Like, for example, you enter into an agreement that would be contrary doon sa public policy ngayon ng pagsusuot or in compliance with health protocols because of COVID-19, no? Na you encourage, it is a contract that would encourage one of the parties not to wear yung mga health protocols or not to comply with health protocols, then that would be contrary to public policy, and also, of course, contrary to law, because there is a law that requires for the public or for anyone to comply with health protocols. And so this freedom of contract is not absolute. And then the obligatoriness of contract, it is based on Article 1315 in relation to Article 1159, which states that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. So whatever is agreed upon by the parties mutually and freely, they are bound by that contract, and it becomes a law between them. And so the terms and conditions of their contracts must be complied with in good faith. And then you take note of the stages in the life of a contract. Starts with preparation or negotiation when an offer is made. And then you have the perfection when there is already an agreement. Perfection comes when there is already a concurrence of all the essential requisites of an obligation. There is a concurrence of the consent, the object, and the consideration. And the consummation takes place when there is already an execution of the contract. Another characteristic would be the mutuality of contracts, no? Which states that contracts must bind both the parties, and the validity or compliance could not be left to the will of any of them. No, dapat they are bound. Both of them are bound by their contract. Hindi lang yung sa isa. And we have again yung consensuality of contracts, which is based in Article 1315 that contracts are perfected as a general rule by mere consent. This is the general rule. Again, I have to emphasize that there are forms of contracts that they must be in writing for validity, no, or for enforceability. But as a general rule, as long as the three essential requisites have concord, there is already a perfected contract, no? And from that moment on, the parties are bound to fulfill their respective obligation under the contract that they have entered into. And relativity of contracts is based on Article 1311, which states that contracts take effect only between the parties, their assigns, and heirs. Ibig sabihin ay it binds them only and as their assigns and heirs. Kaya kung papansin nyo sa kontrata, halimbawa it's a contract of sale that, for example, the seller undertakes to sell, transfer, cede all his rights and claims with respect to a parcel of land to buyer, his heirs, and assigns. Ibig sabihin ay it creates a real rights that would bind kahit mamatay yung party, it will be subject to succession. Pwedeng manahin ng kanyang rights ng kanyang mga heirs and even yung kanyang mga assigns. Or even yung kung sino man yung kanino niya i-assign yung right na yon, not necessarily yung heirs. It could be, for example, merong especially so sa mga sa ownership with respect to shares of stocks, yung mga ganon, or to rights, real rights or claims with respect to certain obligations or to certain properties, no? Yung rights na yon, they could be subject to assignment to other parties. And so these assigns and even yung heirs, mga tagapagmana, they come in succession, no? To the party, and so they are bound by the contract that has been entered into by the party to whom they get their rights of succession. The rights and obligations arising from the contract are not transmissible by their nature or by stipulation or by provision of law. A contract can only bind the parties who entered into or their successors who assume their personalities. No, parties to a contract cannot impose any liability on anyone who is a stranger to the contract kasi nga because of the mutuality of the agreement of the parties. And so you could not bind other parties to your contract where those parties are stranger to the contract. In order to bind other parties, they must have to assent or to consent to such obligation, no? Like kung halimbawa si A ay umutang kay B and so si A ang merong obligation magbayad. Siya lang ang merong obligation magbayad. However, hindi po pwede na they enter into a contract na si C ang magbabayad ng utang ni A. Not unless C would voluntarily do so, no? But that would now fall under natural obligation, or not unless they notify C and C agrees to be bound by the contract entered into by A and B and assume the obligation of A. There are, however, exceptions to the principle of relativity of contracts. First of which would be yung for a truly, no? If a contract should contain some stipulation in favor of third person, no, there is a benefit that is vested to another person, then he may demand the fulfillment provided he communicated his acceptance to the obligor before its obligation. And in contracts creating real rights, no, third persons who came to, ito yung mga buyer in good faith that they, pag sinabi mong buyer in good faith, they relied upon yung representation based doon sa titulo, and they don't know of, they did not have any knowledge of any defect, no, nung title or even yung title ng seller when nung binebenta. And so in case after the perfection of the contract of sale, there is a vice or merong ground for its annulment. But if it is a buyer in good faith, then that the right of the third person, no, could not be disturbed. Also, creditors are protected in cases of contracts intended to defraud them. And in case any third person who induces another to violate his contract, no, shall be liable for damages. So these persons, although they are not bound by the contract, no, but by virtue of provision of the law, they have in one way or another, like yung mga creditors, no, they have indirect interest over certain properties. Kasi in case of insolvency or in case of liquidation, they take part in those proceedings. And so, kapag naibenta, for example, yung certain property and ng isang borrower. And it is intended to defraud yung creditors, even if the creditors are not a party to a contract of sale that is entered into nung debtor. The creditors have a right to seek for the annulment of the sale, which of the contract of sale that is intended to defraud them. And it becomes an exception to the relativity of contracts kasi essentially ay wala naman talagang pakialam ang creditor doon sa contract that has been entered into. But since the law provides that it is an exemption, and so creditors would now have a right to go after and seek for the annulment of such contracts. Also, with respect to a third person who induces another to violate his contract shall be liable for damages to the other contracting parties. You take note of the definition of a contract of adhesion, a contract whereby almost all of its provisions are drafted by one party. Naalala nyo yung paghalimbawa, nagsasign kayo ng mga subscription agreement. Kahit yung sa mga pag nag-download kayo ng apps, tapos may terms and conditions, di nyo naman, aniliit, di nyo naman binabasa lahat, nag-accept lang kayo, nag-agree lang kayo. Those are examples of contract of adhesion. No? You just agree, you just affix your signature. And so it is, yung other party would just adhere yung doon sa whatever is imposed by him, by the other party. And its face, it violates yung freedom of to contract of the parties. Kasi di ba supposedly, if you are free to freedom or autonomy of contract requires that the parties would be on equal footing to negotiate the terms and conditions. Pero sa contract of adhesion, ay meron nang nakaprepare na terms and condition at mag-agree na lang yung isang party. Pipirma na lang siya, no? I-affix na lang niya yung kanyang signature. It is not contracts of adhesion, no? Although apparently kung titignan mo, they are in violation ng sa freedom or autonomy of contract. But as long as yung contract, no, contract of adhesion becomes void only when the dominant party takes advantage of the weakness of the other. So it is not necessarily na a contract of adhesion is invalid per se. And at the same time, kung before yung sa contract of adhesion, before yung affixing ng signature, merong opportunity yung the other party affixing his signature to verify or to check the terms and conditions, no? And he was made fully aware of the contents ng contract, then that would become valid. It becomes invalid when there is taking of advantage of the weakness of the other and completely depriving the latter an opportunity, no, to verify or to check on the terms and conditions ng kanyang pinipirmahang kontrata. Otherwise, the presumption would be contracts of adhesion, they are not invalid per se. And so that would be all for the part 1 ng ating lecture. Then next would be an essential requisites of contracts.